Dictation will start in 5 seconds. Get ready. Start. This appeal is directed against the judgment and order dated 27/9/2012 passed by the Allahabad High Court upholding the conviction of the appellant along with others under sections 148 and 302/149 of the Indian Penal Code 1860 IPC. It may be mentioned that learned Sessions Judge Eta Wide the judgment and order dated 21/1997 passed in the Sessions Trial number 17 of 1993 convicted the appellant along with three others under sections 148 and 302/149 IPC and sentenced each of them to undergo rigorous imprisonment for 2 years and to pay fine of rupees 2000 for the conviction under section 148 IPC with a default stipulation and further sentenced to undergo imprisonment for life under section 302/149 IPC. Another accused, Sri Dev, was convicted for the offences punishable under sections 147 and 302/149 IPC. He was sentenced to undergo rigorous imprisonment for 2 years and to pay fine of rupees 2000 with a default stipulation for the offence committed under section 147 IPC and to suffer imprisonment for life under section 302/149 IPC. Being aggrieved by the aforesaid conviction and sentence, all the 5 accused persons, including the appellant herein, preferred criminal appeal under section 374 of the Code of Criminal Procedure 1973 CRPC before the Allahabad High Court (High Court), which was registered as Criminal Appeal number 340 of 1997. By the judgment and order dated 27/9/2012, a division bench of the High Court affirmed the conviction and sentence of all the accused persons, including that of the appellant, and dismissed the criminal appeal. The appellant then preferred petition for special leave to appeal before this court, being SLP criminal number 750/2013. This court, vide the order dated 4/2/2013, had issued notice on the special leave petition as well as on the application for bail. On 30/6/2014, this court granted leave but rejected the prayer for bail. It was thereafter that criminal appeal number 1348 of 2014 came to be registered. We have heard learned counsel for the parties. A written report of the incident scribed by Kuldeep Kumar Tiwari, that is, the FIR, was submitted by Sarvan Kumar at 5:10 p.m. on the same day at police station Soro. It was mentioned that Sri Dev, deceased Satyanarayan, and Lakshmi Narayan were the 3 brothers. Lakshmi Narayan, who was the youngest of the 3, had no issue, so he had executed a will in favor of Satyanarayan's sons. Sri Dev and his sons, including the appellant Nityanand, were enraged by this disposition of property by Lakshmi Narayan. This led to filing of several cases between them. Due to such litigation, there was an old enmity, and for that reason, the accused persons had fatally assaulted Satyanarayan on that fateful day. On the basis of the FIR, crime number 237/1992 was registered at police station Soro under sections 147, 148, 149 and 302 IPC. The investigating officer had carried out investigation of the case. The post-mortem report indicated multiple ante-mortem injuries on the person of the deceased. On completion of the investigation, charges under sections 148 and 302/149 IPC were framed against the accused Munna, Raju, Uchav, alias Pappu, and Nityanand. Similarly, charges under sections 147 and 302/149 IPC were framed against the accused Sri Dev. The accused persons denied the charges and claimed to be tried. To prove its case, the prosecution examined a total of 5 witnesses. After closure of the prosecution evidence, statements of the accused persons were recorded under Section 313 CRPC. The trial court, on an appreciation of the evidence adduced and considering the materials on record, convicting the accused Sri Dev under sections 147 and 302/149 IPC, and also convicted the appellant and the other sons of Sri Dev, that is Munna Lal, Raju and Uchav alias Pappu, under sections 148 and 302/149 IPC. All the accused were thereafter sentenced as indicated above. In appeal, the High Court observed that the eyewitnesses' account of the incident stood fully corroborated by the medical evidence. Prosecution has proved its case beyond all reasonable doubt against each of the accused. Therefore, while upholding the conviction and sentence, the High Court dismissed the appeal. Learned counsel for the appellant submits that both the trial court and the High Court committed a manifest error in convicting the appellant under sections 148 and 302/149 IPC. He submits that allegation against the appellant was that he was carrying a country-made pistol. As the informant and others tried to rush towards Satyanarayan on hearing his cries as he was being assaulted by the other accused persons, appellant Nityanand fired from his country-made pistol, thereby threatening the informant and the others who tried to rescue Satyanarayan. Stop.